Human rights are moral principles or norms that establish standards of human behavior and are regularly protected as substantive rights in municipal and international law. They are commonly understood as inalienable, fundamental rights to which a person is inherently entitled simply because he or she is a human being and which are inherent in all human beings, regardless of age, ethnic origin, location, language, religion, ethnicity, or any other status. They are applicable everywhere and at all times in the sense of being universal, and they are egalitarian in the sense of being the same for everyone. They are regarded as requiring empathy and the rule of law, and imposing an obligation on individuals to respect the human rights of others. It is generally considered that they should not be taken away except as a result of due process based on specific circumstances. The doctrine of human rights has been highly influential within international law and global and regional institutions. The precise meaning of the term right is controversial and remains the subject of ongoing philosophical debate. While there is consensus that human rights encompass a wide variety of rights, such as the right to a fair trial, protection against enslavement, prohibition of genocide, free speech, and the right to education, there is disagreement about which of these particular rights should be included within the general framework of human rights. Some thinkers suggest that human rights should serve as a minimum requirement to avoid the worst-case abuses, while others see it as a higher standard. Many of the basic ideas that animated the human rights movement developed in the aftermath of the Second World War and the events of the Holocaust, culminating in the adoption of the Universal Declaration of Human Rights in Paris by the United Nations General Assembly in 1948. Ancient peoples did not share the modern-day conception of universal human rights. The true forerunner of human rights discourse was the concept of natural rights, which first appeared as part of the medieval natural law tradition and developed in new directions during the European Enlightenment with philosophers such as John Locke, Francis Hutcheson, and Jean-Jacques Burlamaqui. This concept featured prominently in the political discourse of the American Revolution and the French Revolution. From this foundation, modern human rights arguments emerged over the latter half of the 20th century, possibly as a reaction to slavery, torture, genocide, and war crimes. Many of the basic ideas that animated the human rights movement developed in the aftermath of the Second World War and the events of the Holocaust, culminating in the adoption of the Universal Declaration of Human Rights in Paris by the United Nations General Assembly in 1948. Ancient peoples did not have the same modern-day conception of universal human rights. However, the concept has in some sense existed for centuries, although not in the same way as today. The true forerunner of human rights discourse was the concept of natural rights, which first appeared as part of the medieval natural law tradition. It developed in new directions during the European Enlightenment with such philosophers as John Locke, Francis Hutcheson, and Jean-Jacques Burlamaqui, and featured prominently in the political discourse of the American Revolution and the French Revolution. From this foundation, the modern human rights arguments emerged over the latter half of the 20th century, possibly as a reaction to slavery, torture, genocide, and war crimes. The medieval natural law tradition was heavily influenced by the writings of St. Paul's early Christian thinkers such as Saint Hilary of Poitiers, Saint Ambrose, and Saint Augustine. 17 Augustine was among the earliest to examine the legitimacy of the laws of man, and attempt to define the boundaries of what laws and rights occur naturally based on wisdom and conscience, instead of being arbitrarily imposed by mortals, and if people are obligated to obey laws that are unjust. Spanish scholasticism insisted on a subjective vision of law during the 16th and 17th centuries. Luis de Molina, Domingo de Soto and Francisco Vitoria, members of the School of Salamanca, defined law as a moral power over one's own. 50 Although they maintained at the same time the idea of law as an objective order, they stated that there are certain natural rights, mentioning both rights related to the body, right to life, to property, and to the spirit, right to freedom of thought, dignity. The jurist Vázquez de Menchaca, starting from an individualist philosophy, was decisive in the dissemination of the term ira naturalia. This natural law thinking was supported by contact with American civilizations and the debate that took place in Castile about the just titles of the conquest and, in particular, the nature of the indigenous people. In the Castilian colonization of America, it is often stated, measures were applied in which the germs of the idea of human rights are present, debated in the well-known Valladolid debate that took place in 1550 and 1551. The thought of the school of Salamanca, especially through Francisco Vitoria, also contributed to the promotion of European natural law. From this foundation, the modern human rights arguments emerged over the latter half of the 20th century. Magna Carta is an English charter originally issued in 1215 which influenced the development of the common law and many later constitutional documents related to human rights, such as the 1689 English Bill of Rights, the 1789 United States Constitution, and the 1791 United States Bill of Rights. 17th-century English philosopher John Locke discussed natural rights in his work, identifying them as being life, liberty, and estate, property, and argued that such fundamental rights could not be surrendered in the social contract. In Britain in 1689, the English Bill of Rights and the Scottish Claim of Right each made a range of oppressive governmental actions illegal. Two major revolutions occurred during the 18th century, in the United States, 1776, and in France, 1789, leading to the United States Declaration of Independence and the French Declaration of the Rights of Man and of the Citizen respectively, both of which articulated certain human rights. Additionally, the Virginia Declaration of Rights of 1776 encoded into law a number of fundamental civil rights and civil freedoms. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. United States Declaration of Independence, 1776. 1800 to World War I. Philosophers such as Thomas Paine, John Stuart Mill, and Hegel expanded on the theme of universality during the 18th and 19th centuries. In 1831, William Lloyd Garrison wrote in a newspaper called The Liberator that he was trying to enlist his readers in the great cause of human rights, so the term human rights probably came into use sometime between Paine's The Rights of Man and Garrison's publication. In 1849 a contemporary, Henry David Thoreau, wrote about human rights in his treatise on the duty of civil disobedience which was later influential on human rights and civil rights thinkers. United States Supreme Court Justice David Davis, in his 1867 opinion for Ex parte Milligan, wrote by the protection of the law, human rights are secured, withdraw that protection and they are at the mercy of wicked rulers or the clamor of an excited people. Many groups and movements have managed to achieve profound social changes over the course of the 20th century in the name of human rights. In Western Europe and North America, labor unions brought about laws granting workers the right to strike, establishing minimum work conditions and forbidding or regulating child labor. The women's rights movement succeeded in gaining for many women the right to vote. National liberation movements in many countries succeeded in driving out colonial powers. One of the most influential was Mahatma Gandhi's leadership of the Indian independence movement. Movements by long oppressed racial and religious minorities succeeded in many parts of the world, among them the civil rights movement, and more recent diverse identity politics movements, on behalf of women and minorities in the United States. The foundation of the International Committee of the Red Cross, the 1864 Lieber Code and the first of the Geneva Conventions in 1864 laid the foundations of international humanitarian law, to be further developed following the two world wars. Between World War I and World War II, the League of Nations was established in 1919 at the negotiations over the Treaty of Versailles following the end of World War I. The League's goals included disarmament, preventing war through collective security, settling disputes between countries through negotiation, diplomacy, and improving global welfare. Enshrined in its charter was a mandate to promote many of the rights which were later included in the Universal Declaration of Human Rights. The League of Nations had mandates to support many of the former colonies of the Western European colonial powers during their transition from colony to independent state. Established as an agency of the League of Nations, and now part of United Nations, the International Labour Organization also had a mandate to promote and safeguard certain of the rights later included in the Universal Declaration of Human Rights, UDHR. The primary goal of the ILO today is to promote opportunities for women and men to obtain decent and productive work, in conditions of freedom, equity, security, and human dignity. Report by the Director General for the International Labour Conference 87th Session. The Universal Declaration of Human Rights, UDHR, is a non-binding declaration adopted by the United Nations General Assembly in 1948, partly in response to the events of World War II. The UDHR urges member states to promote a number of human, civil, economic, and social rights, asserting these rights are part of the foundation of freedom, justice, and peace in the world. The declaration was the first international legal effort to limit the behavior of states and make sure they did their duties to their citizens following the model of the rights-duty duality. Recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Preamble to the Universal Declaration of Human Rights, 1948. The UDHR was framed by members of the Human Rights Commission, with Eleanor Roosevelt as chair, who began to discuss an international Bill of Rights in 1947. The members of the Commission did not immediately agree on the form of such a Bill of Rights, and whether, or how, it should be enforced. The Commission proceeded to frame the UDHR and accompanying treaties, but the UDHR quickly became the priority. Canadian law professor John Humphrey and French lawyer René Cassin were responsible for much of the cross-national research and the structure of the document respectively, where the articles of the Declaration were interpretative of the general principle of the preamble. The document was structured by Cassin to include the basic principles of dignity, liberty, equality, and brotherhood in the first two articles, followed successively by rights pertaining to individuals, rights of individuals in relation to each other and to groups, spiritual, public, and political rights, and economic, social, and cultural rights. The final three articles place, according to Cassin, rights in the context of limits, duties, and the social and political order in which they are to be realized. Humphrey and Cassin intended the rights in the UDHR to be legally enforceable through some means, as is reflected in the third clause of the preamble. Whereas it is essential, if man is not to be compelled to have recourse, as a last resort, to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Preamble to the Universal Declaration of Human Rights, 1948. Some of the UDHR was researched and written by a committee of international experts on human rights, including representatives from all continents and all major religions, and drawing on consultation with leaders such as Mahatma Gandhi. The inclusion of both civil and political rights and economic, social, and cultural rights was predicated on the assumption that basic human rights are indivisible and that the different types of rights listed are inextricably linked. Although this principle was not opposed by any member states at the time of adoption, the declaration was adopted unanimously, with the abstention of the Soviet bloc, apartheid South Africa, and Saudi Arabia. This principle was later subject to significant challenges. On the issue of the term universal, the declarations did not apply to domestic discrimination or racism. Henry J. Richardson III argued. All major governments at the time of drafting the UN Charter and the Universal Declaration did their best to ensure, by all means known to domestic and international law, that these principles had only international application and carried no legal obligation on those governments to be implemented domestically. All tacitly realized that for their own discriminated against minorities to acquire leverage on the basis of legally being able to claim enforcement of these wide-reaching rights would create pressures that would be political dynamite. The onset of the Cold War soon after the UDHR was conceived brought to the fore divisions over the inclusion of both economic and social rights and civil and political rights in the Declaration. Capitalist states tended to place strong emphasis on civil and political rights, such as freedom of association and expression, and were reluctant to include economic and social rights, such as the right to work and the right to join a union. Socialist states placed much greater importance on economic and social rights and argued strongly for their inclusion. 31 Because of the divisions over which rights to include and because some states declined to ratify any treaties including certain specific interpretations of human rights, and despite the Soviet bloc and a number of developing countries arguing strongly for the inclusion of all rights in a unity resolution, the rights enshrined in the UDHR were split into two separate covenants, allowing states to adopt some rights and derogate others. Although this allowed the covenants to be created, it denied the proposed principle that all rights are linked, which was central to some interpretations of the UDHR. Although the UDHR is a non-binding resolution, it is now considered to be a central component of international customary law which may be invoked under appropriate circumstances by state judiciaries and other judiciaries. Human Rights Treaties. In 1966, the International Covenant on Civil and Political Rights, ICPIR, and the International Covenant on Economic, Social, and Cultural Rights, ISCR, were adopted by the United Nations, between them making the rights contained in the UDHR binding on all states. They came into force only in 1976, when they were ratified by a sufficient number of countries, despite achieving the ICPIR, a covenant including no economic or social rights. The US only ratified the ICPIR in 1992. The ISCR commits 155 state parties to work toward the granting of economic, social, and cultural rights, ESCR, to individuals. Numerous other treaties, pieces of legislation, have been offered at the international level. They are generally known as human rights instruments. Some of the most significant are: Convention on the Prevention and Punishment of the Crime of Genocide, adopted 1948, entry into force, 1951, on hchr.ch. Convention on the Elimination of All Forms of Racial Discrimination, CERD, adopted 1966, entry into force, 1969, on hchr.ch. Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, entry into force, 1981, Convention on the Elimination of All Forms of Discrimination Against Women. United Nations Convention Against Torture, CAT, adopted 1984, entry into force, 1984, 35. Convention on the Rights of the Child, CRC, adopted 1989, entry into force, 1989, Convention on the Rights of the Child UNICEF archived April 26, 2019 at the Wayback Machine. International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, ICRMUA, adopted 1990. Rome Statute of the International Criminal Court, ICC, entry into force. 2002. Including environmental rights. In 2021 the United Nations Human Rights Council officially recognized having a clean, healthy, and sustainable environment as a human right. In April 2024, the European Court of Human Rights ruled, for the first time in history, that the Swiss government had violated human rights by not acting strongly enough to stop climate change. Responsibility to protect refers to a doctrine for United Nations member states to intervene to protect populations from atrocities. It has been cited as justification in the use of recent military interventions. An example of an intervention that is often criticized is the 2011 military intervention in the First Libyan Civil War by NATO and Qatar, where the goal of preventing atrocities is alleged to have taken upon itself the broader mandate of removing the target government. Economic sanctions are often levied upon individuals or states who commit human rights violations. Sanctions are often criticized for its feature of collective punishment in hurting a country's population economically in order to dampen that population's view of its government. It is also argued that, counterproductively, sanctions on offending authoritarian governments strengthen that government's position domestically, as governments would still have more mechanisms to find funding than their critics and opposition, who become further weakened. The risk of human rights violations increases with the increase in financially vulnerable populations. Girls from poor families in non-industrialized economies are often viewed as a financial burden on the family, and marriage of young girls is often driven in the hope that daughters will be fed and protected by wealthier families. 43. Female genital mutilation and force-feeding of daughters is argued to be similarly driven in large part to increase their marriage prospects and thus their financial security by achieving certain idealized standards of beauty. In certain areas, girls requiring the experience of sexual initiation rites with men and passing sex training tests on girls are designed to make them more appealing as marriage prospects. Measures to help the economic status of vulnerable groups in order to reduce human rights violations include girls' education and guaranteed minimum incomes and conditional cash transfers, such as Bolsa Familia, which subsidize parents who keep children in school rather than contributing to family income, has successfully reduced child labor. Informational strategies. See also, human rights education and activism. Human rights abuses are monitored by United Nations committees, national institutions, and governments, and by many independent non-governmental organizations, such as Amnesty International, Human Rights Watch, World Organization Against Torture, Freedom House, International Freedom of Expression Exchange, and Anti-Slavery International. These organizations collect evidence and documentation of human rights abuses and apply pressure to promote human rights. Educating people on the concept of human rights has been argued as a strategy to prevent human rights abuses. Legal instruments. Many examples of legal instruments at the international, regional, and national level described below are designed to enforce laws securing human rights. The United Nations, UN, is the only multilateral governmental agency with universally accepted international jurisdiction for universal human rights legislation. All UN organs have advisory roles to the United Nations Security Council and the United Nations Human Rights Council, and there are numerous committees within the UN with responsibilities for safeguarding different human rights treaties. The most senior body of the UN with regard to human rights is the Office of the High Commissioner for Human Rights. The United Nations has an international mandate to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion. Article 1-3 of the Charter of the United Nations. The UN Human Rights Council, created in 2005, has a mandate to investigate alleged human rights violations. 47 of the 193 UN member states sit on the Council, elected by simple majority in a secret ballot of the United Nations General Assembly. Members serve a maximum of 6 years and may have their membership suspended for gross human rights abuses. The Council is based in Geneva, and meets 3 times a year, with additional meetings to respond to urgent situations. Independent experts, rapporteurs, are retained by the Council to investigate alleged human rights abuses and to report to the Council. The Human Rights Council may request that the Security Council refer cases to the International Criminal Court, ICC, even if the issue being referred is outside the normal jurisdiction of the ICC. United Nations treaty bodies. In addition to the political bodies whose mandate flows from the UN Charter, the UN has set up a number of treaty-based bodies, comprising committees of independent experts who monitor compliance with human rights standards and norms flowing from the core international human rights treaties. They are supported by and are created by the treaty that they monitor, with the exception of the CESCR, which was established under a resolution of the Economic and Social Council to carry out the monitoring functions originally assigned to that body under the Covenant. They are technically autonomous bodies, established by the treaties that they monitor and accountable to the state parties of those treaties, rather than subsidiary to the United Nations, though in practice they are closely intertwined with the United Nations system and are supported by the UN High Commissioner for Human Rights, UNCR, and the UN Center for Human Rights. The Human Rights Committee promotes participation with the standards of the ICPIR. The members of the committee express opinions on member countries and make judgments on individual complaints against countries which have ratified an optional protocol to the treaty. The judgments, termed views, are not legally binding. The member of the committee meets around 3 times a year to hold sessions. The Committee on Economic, Social, and Cultural Rights monitors the ISGRA and makes general comments on ratifying countries' performance. It will have the power to receive complaints against the countries that opted into the optional protocol once it has come into force. Unlike the other treaty bodies, the Economic Committee is not an autonomous body responsible to the treaty parties, but directly responsible to the Economic and Social Council and ultimately to the General Assembly. This means that the Economic Committee faces particular difficulties at its disposal, only relatively weak means of implementation in comparison to other treaty bodies. 53 particular difficulties noted by commentators include: perceived vagueness of the principles of the treaty, relative lack of legal texts and decisions, ambivalence of many states in addressing economic, social, and cultural rights, comparatively few non-governmental organizations focused on the area, and problems with obtaining relevant and precise information. The Committee on the Elimination of Racial Discrimination monitors the CERD and conducts regular reviews of countries' performance. It can make judgments on complaints against member states allowing it, but these are not legally binding. It issues warnings to attempt to prevent serious contraventions of the Convention. The Committee on the Elimination of Discrimination Against Women monitors the CEDAW. It receives states' reports on their performance and comments on them, and can make judgments on complaints against countries which have opted into the 1999 optional protocol. The Committee Against Torture monitors the CAT and receives states' reports on their performance every 4 years and comments on them. Its subcommittee may visit and inspect countries which have opted into the optional protocol. The Committee on the Rights of the Child monitors the CRC and makes comments on reports submitted by states every 5 years. It does not have the power to receive complaints. The Committee on Migrant Workers was established in 2004 and monitors the ICRMU and makes comments on reports submitted by states every 5 years. It will have the power to receive complaints of specific violations only once 10 member states allow it. The Committee on the Rights of Persons with Disabilities was established in 2008 to monitor the Convention on the Rights of Persons with Disabilities. It has the power to receive complaints against the countries which have opted into the optional protocol to the Convention on the Rights of Persons with Disabilities. The Committee on Enforced Disappearances monitors the ICT. All states parties are obliged to submit reports to the Committee on how the rights are being implemented. The committee examines each report and addresses its concerns and recommendations to the state party in the form of concluding observations. Each treaty body receives secretariat support from the Human Rights Council and Treaties Division of Office of the High Commissioner on Human Rights, OCHR, in Geneva except CEDAW, which is supported by the Division for the Advancement of Women, DA. CEDAW formerly held all its sessions at United Nations headquarters in New York but now frequently meets at the United Nations office in Geneva. The other treaty bodies meet in Geneva. The Human Rights Committee usually holds its March session in New York City. The human rights enshrined in the UDHR, the Geneva Conventions and the various enforced treaties of the United Nations are enforceable in law. In practice, many rights are very difficult to legally enforce due to the absence of consensus on the application of certain rights, the lack of relevant national legislation or of bodies empowered to take legal action to enforce them. International courts. There exist a number of internationally recognized organizations with worldwide mandate or jurisdiction over certain aspects of human rights. The International Court of Justice, ICJ, is the United Nations primary judiciary body. It has worldwide jurisdiction. It is directed by the Security Council. The ICJ settles disputes between nations. The ICJ does not have jurisdiction over individuals. The International Criminal Court, ICC, is the body responsible for investigating and punishing war crimes, and crimes against humanity when such occur within its jurisdiction, with a mandate to bring to justice perpetrators of such crimes that occurred after its creation in 2002. A number of UN members have not joined the court and the ICC does not have jurisdiction over their citizens, and others have signed but not yet ratified the Rome Statute, which established the court. The ICC and other international courts exist to take action where the national legal system of a state is unable to try the case itself. If national law is able to safeguard human rights and punish those who breach human rights legislation, it has primary jurisdiction by complementarity. Only when all local remedies have been exhausted does international law take effect. In over 110 countries, national human rights institutions, NHRIs, have been set up to protect, promote, or monitor human rights with jurisdiction in a given country. Although not all NHRIs are compliant with the Paris Principles, the number and effect of these institutions is increasing. The Paris Principles were defined at the first International Workshop on National Institutions for the Promotion and Protection of Human Rights in Paris on 7–9 October 1991, and adopted by United Nations Human Rights Commission Resolution 1992/54 of 1992 and the General Assembly Resolution 48/134 of 1993. The Paris Principles list a number of responsibilities for national institutions. The African Union, O, is a continental union consisting of 55 African states. Established in 2001, the O's purpose is to help secure Africa's democracy, human rights, and a sustainable economy, especially by bringing an end to intra-African conflict and creating an effective common market. The African Commission on Human and People's Rights, ACPER, is a quasi-judicial organ of the African Union tasked with promoting and protecting human rights and collective, people's, rights throughout the African continent, as well as interpreting the African Charter on Human and People's Rights and considering individual complaints of violations of the Charter. The Commission has three broad areas of responsibility: promoting human and people's rights, protecting human and people's rights, interpreting the African Charter on Human and People's Rights. In pursuit of these goals, the Commission is mandated to collect documents, undertake studies and researches on African problems in the field of human and people's rights, organize seminars, symposia and conferences, disseminate information, encourage national and local institutions concerned with human and people's rights and, should the case arise, give its views or make recommendations to governments. Charter, Art 45. With the creation of the African Court on Human and People's Rights, under a protocol to the Charter which was adopted in 1998 and entered into force in January 2004, the Commission will have the additional task of preparing cases for submission to the Court's jurisdiction. In a July 2004 decision, the O Assembly resolved that the future Court on Human and People's Rights would be integrated with the African Court of Justice. The Court of Justice of the African Union is intended to be the principal judicial organ of the Union. Protocol of the Court of Justice of the African Union, Article 2.2. Although it has not yet been established, it is intended to take over the duties of the African Commission on Human and People's Rights, as well as act as the Supreme Court of the African Union, interpreting all necessary laws and treaties. The protocol establishing the African Court on Human and People's Rights entered into force in January 2004, but its merging with the Court of Justice has delayed its establishment. The protocol establishing the Court of Justice will come into force when ratified by 15 countries. There are many countries in Africa accused of human rights violations by the international community and NGOs. The Organization of American States, OAS, is an international organization, headquartered in Washington, D.C., United States. Its members are the 35 independent states of the Americas. Over the course of the 1990s, with the end of the Cold War, the return to democracy in Latin America, and the thrust toward globalization, the OAS made major efforts to reinvent itself to fit the new context. Its stated priorities now include the following: strengthening democracy, working for peace, protecting human rights, combating corruption, the rights of indigenous peoples, promoting sustainable development. The Inter-American Commission on Human Rights, the IACR, is an autonomous organ of the Organization of American States, also based in Washington, D.C. Along with the Inter-American Court of Human Rights, based in San Jose, Costa Rica, it is one of the bodies that comprise the Inter-American System for the Promotion and Protection of Human Rights. The IACRA is a permanent body which meets in regular and special sessions several times a year to examine allegations of human rights violations in the hemisphere. Its human rights duties stem from three documents: the American Convention on Human Rights, the American Declaration of the Rights and Duties of Man, the Charter of the Organization of American States. The Inter-American Court of Human Rights was established in 1979 with the purpose of enforcing and interpreting the provisions of the American Convention on Human Rights. Its two main functions are thus adjudicatory and advisory. Under the former, it hears and rules on the specific cases of human rights violations referred to it. Under the latter, it issues opinions on matters of legal interpretation brought to its attention by other OAS bodies or member states. There are no Asia-wide organizations or conventions to promote or protect human rights. Countries vary widely in their approach to human rights and their record of human rights protection. The Association of Southeast Asian Nations, ASEAN, is a geopolitical and economic organization of 10 countries located in Southeast Asia, which was formed in 1967 by Indonesia, Malaysia, the Philippines, Singapore, and Thailand. The organization now also includes Brunei Darussalam, Vietnam, Laos, Myanmar, and Cambodia. In October 2009, the ASEAN Intergovernmental Commission on Human Rights was inaugurated, and subsequently, the ASEAN Human Rights Declaration was adopted unanimously by ASEAN members on November 18, 2012. The Arab Charter on Human Rights, ACHR, was adopted by the Council of the League of Arab States on May 22, 2004. The Council of Europe, founded in 1949, is the oldest organization working for European integration. It is an international organization with legal personality recognized under public international law and has observer status with the United Nations. The seat of the Council of Europe is in Strasbourg in France. The Council of Europe is responsible for both the European Convention on Human Rights and the European Court of Human Rights. These institutions bind the Council's members to a code of human rights which, though strict, are more lenient than those of the United Nations Charter on Human Rights. The Council also promotes the European Charter for Regional or Minority Languages and the European Social Charter. Membership is open to all European states which seek European integration, accept the principle of the rule of law and are able and willing to guarantee democracy, fundamental human rights and freedoms. The Council of Europe is an organization that is not part of the European Union, but the latter is expected to accede to the European Convention and potentially the Council itself. The EU has its own human rights document, the Charter of Fundamental Rights of the European Union. The European Convention on Human Rights defines and guarantees since 1950 human rights and fundamental freedoms in Europe. All 47 member states of the Council of Europe have signed this convention and are therefore under the jurisdiction of the European Court of Human Rights in Strasbourg. In order to prevent torture and inhuman or degrading treatment, Article 3 of the Convention, the European Committee for the Prevention of Torture was established. Universal jurisdiction is a controversial principle in international law whereby states claim criminal jurisdiction over persons whose alleged crimes were committed outside the boundaries of the prosecuting state, regardless of nationality, country of residence, or any other relation with the prosecuting country. The state backs its claim on the grounds that the crime committed is considered a crime against all, which any state is authorized to punish. The concept of universal jurisdiction is therefore closely linked to the idea that certain international norms are erga omnes, or owed to the entire world community, as well as the concept of jus cogens. In 1993, Belgium passed a law of universal jurisdiction to give its courts jurisdiction over crimes against humanity in other countries, and in 1998 Augusto Pinochet was arrested in London following an indictment by Spanish Judge Baltasar Garzon under the universal jurisdiction principle. The principle is supported by Amnesty International and other human rights organizations as they believe certain crimes pose a threat to the international community as a whole and the community has a moral duty to act, but others, including Henry Kissinger, argue that state sovereignty is paramount, because breaches of rights committed in other countries are outside state sovereign interest and because states could use the principle for political reasons. State and non-state actors. Companies, NGOs, political parties, informal groups, and individuals are known as non-state actors. Non-state actors can also commit human rights abuses, but are not subject to human rights law other than international humanitarian law, which applies to individuals. Multinational companies play an increasingly large role in the world, and are responsible for a large number of human rights abuses. Although the legal and moral environment surrounding the actions of governments is reasonably well developed, that surrounding multinational companies is both controversial and ill-defined. Multinational companies often view their primary responsibility as being to their shareholders, not to those affected by their actions. Such companies are often larger than the economies of the states in which they operate, and can wield significant economic and political power. No international treaties exist to specifically cover the behavior of companies with regard to human rights, and national legislation is very variable. Jean Ziegler, Special Rapporteur of the UN Commission on Human Rights on the Right to Food, stated in a report in 2003. The growing power of transnational corporations and their extension of power through privatization, deregulation, and the rolling back of the state also mean that it is now time to develop binding legal norms that hold corporations to human rights standards and circumscribe potential abuses of their position of power. Jean Ziegler. In August 2003, the Human Rights Commission's Subcommission on the Promotion and Protection of Human Rights produced draft norms on the responsibilities of transnational corporations and other business enterprises with regard to human rights. These were considered by the Human Rights Commission in 2004, but have no binding status on corporations and are not monitored. Additionally, the United Nations Sustainable Development Goal 10 aims to substantially reduce inequality by 2030 through the promotion of appropriate legislation. Human rights in emergency situations. With the exception of non-derogable human rights, international conventions class the right to life, the right to be free from slavery, the right to be free from torture, and the right to be free from retroactive application of penal laws as non-derogable. The UN recognizes that human rights can be limited or even pushed aside during times of national emergency, although it clarifies. The emergency must be actual, affect the whole population, and the threat must be to the very existence of the nation. The declaration of emergency must also be a last resort and a temporary measure. United Nations, the resource. Rights that cannot be derogated for reasons of national security in any circumstances are known as peremptory norms or jus cogens. Such international law obligations are binding on all states and cannot be modified by treaty. Critics of the view that human rights are universal argue that human rights are a Western concept that emanate from a European, Judeo-Christian, and/or Enlightenment heritage, typically labeled Western, and cannot be enjoyed by other cultures that don't emulate the conditions and values of Western societies. Right-wing critics of human rights argue that they are unrealistic and unenforceable norms and inappropriate intrusions on state sovereignty, while left-wing critics of human rights argue that they fail to achieve, or prevents better approaches to achieving, progressive goals. Thank you for watching this video.